Welcome, everyone. My name is Alyssa Cooper, and I'm the Executive Director of the Knight-Georgetown Institute, KGI, here at Georgetown. And I'm really delighted to welcome you to Google Search, What Just Happened. I appreciate your patience starting a couple minutes after the hour here, because there was actually a hearing in this case this morning. So it's a very timely event that we're having. Just want to say one word about the Knight-Georgetown Institute. We're a relatively new center based here at Georgetown, dedicated to connecting independent research with technology policy and design, with a focus on the online information environment. And one of our main policy issues that we have put resources and attention to is the concentration of corporate power over that online information environment, and thinking about ways that deconcentrating digital markets could impact the online information ecosystem. So we're really delighted to be co-hosting this event about Google Search here today. And I'm also thrilled to invite my co-host from the Institute for Technology, Law, and Policy, Natalie Roisman, to come say a few words as well.
I didn't realize that was going to be such a steep step, or I would have come up here before you had said my name. Hi, thanks so much, Alyssa. Thanks, everybody. As Alyssa said, I'm Natalie Roisman. I'm the Executive Director of the Georgetown Law Institute for Technology, Law, and Policy, or as we call it shorthand, the Tech Institute. It is really our pleasure to be co-sponsoring this event today. We appreciate the invitation from KGI to join with you on this important topic. I'll also do just a brief 30-second overview about the Institute. We are the home of Georgetown Law's Tech Law and Policy programs for students. That includes the JD Tech Law Scholars Program and the Tech LLM program, as well as a master's program. We also have 20 full-time faculty that are affiliated with our institute, doing a variety of research, workshops, programs, scholarship on an incredible number of important and timely issues, ranging from antitrust and competition to IP, to privacy, social media governance, and pretty much anything else you can think of, and of course, AI. We do a number of events over the course of the year, and it really is a fantastic opportunity to get the chance to partner with KGI and others within our Tech and Society initiative here at Georgetown. And we are glad to be here today. Thanks so much for joining us.
Thanks, Natalie. So on to the main event. I'm really thrilled to introduce Jonathan Sallet, who's Special Assistant Attorney General with the Colorado Attorney General's Office. He's been lead counsel for a coalition of states and territories in the ongoing Google Search antitrust action. He also serves as a senior research fellow at the Mozilla Ramani Center at the Harvard Kennedy School, where he co-teaches the course Big Tech and Competition, and is executive in residence at the Technology and Society Initiative at the Johns Hopkins University Carey School of Business. His past governmental positions include service as Deputy Assistant Attorney General in the Antitrust Division at the Department of Justice, as well as serving as General Counsel of the Federal Communications Commission. John, the floor is yours.
Thank you, everybody, for taking some of your day to listen to this. And thank you especially to Alyssa and Natalie. I think the work in encouraging a greater understanding of tech and society and competition and public policy is at the heart of a series of challenges we face. I work on only one facet of really one of them, and I'll talk about it, but taking the broad view and the comprehensive view that Georgetown does through these programs strikes me as essential. When we came up with the title, I think the literature says a view from the counsel's table, and I forgot to change this slide to say this, but I don't think I had understood that I would be sitting at counsel's table less than a half an hour before I was standing here, but that's in fact what happened. We finished a hearing at about 12:40, and it's a good thing Georgetown is as close to the US courthouse as it is. I want to take a minute to talk about the Google search case. I've been in it for some substantial period of time. I know this because I'm going to make Joe Conrad raise his hand. Joe Conrad and I met in February 2020 at the first meeting I attended of the team that was investigating whether to bring a Google search complaint. And we did, the DOJ did at the end of that year. And just to briefly recap, in 2023, we had an 11-week trial in the US courthouse in DC in front of Judge Mehta. In the following August, the judge ruled that Google had violated Section 2 of the Sherman Act. We went into a remedies phase. This spring, in April and May, we had that evidentiary hearing, which had over 50 witnesses, and his remedies opinion came out on September 2nd of this year. And what I want to do, it's 50-50 that I'm going to press this to go in the correct direction. Okay. I want to just take a minute to say I'm going to express some personal views here, not necessarily those of the Colorado AG's office. I'm going to do that because I think this is a very important case with big implications. But it's so big and the implications are so great that I don't want you to take my word for it. I think it's very important for people to read the opinions. They are not short, but they are detailed. And they are important, and important to listen to what Google says or what commentators say. And we're getting commentary from a variety of angles. It's very important, particularly in an academic setting, I think, that people make up your own mind. So I appreciate the chance to present my views. They are simply one of a set of views that I hope you will consider. So let me start just talking about what this case is about. This case is about how Google kept competitors from getting to users. Businesses need to get to customers. Platforms need to get to users. This case is about what Google did to keep its competitors from getting to users. And those are the users that, as we will discuss in more detail, rivals needed to be successful. They did that largely through default agreements. I'm going to talk about that. They had different manifestations. I'm going to emphasize on browsers because it's a clean example. It's not the only example. So we started in a world where Google's market share was at monopoly levels. The judge found almost 90%. But it was the conduct, of course, that is challenged under Section 2. How did Google maintain its monopoly illegally? Through defaults and distribution agreements. These should be very familiar to all of you. Anybody who's opened up a new smartphone and turned on the browser for the first time knows that if you go to the toolbar and you type a search, you're going to get an answer. Because the browser is preset. It's defaulted to a particular general search engine. It can be changed. We'll come back to the frequency and likelihood of that, but it comes preloaded. And what the judge said, this is from his liability opinion, is that Google has a major, largely unseen advantage, default distribution. And he explained how through a browser or a search widget, the search engine is preset. And then he says, the default is extremely valuable real estate because many users just stick with it. This was an important question of behavioral economics that was discussed during the trial. And Google derives enormous volumes of user data from the searches. So I want you to consider this. I said before that businesses have to get to customers, but what users are to Google is not just a customer. A user is a customer in the sense of looking at the answers Google gives. It's also, he or she is also a contributor through data. And the data contribution is fundamental to understanding this case. Because Google, the judge said, derives extraordinary volumes of user data that it uses to improve the quality of search. I think hanging over the trial was this question. why was Google spending so much money? Billions of dollars. In 2021, Google paid over $26 billion to browsers, manufacturers, companies like Samsung, and mobile carriers in the US, AT&T, T-Mobile, Verizon. On a worldwide basis, in 2022, Google paid Apple $20 billion to be the preset default search engine on Safari and elsewhere. What was it getting? I don't think, to be honest, Google ever gave a very good answer to that question. But there was, in fact, a very good answer. And let me just say, for the law students in the class, in the room, this was a bench trial. There was no jury. And as is typical in a bench trial, judges feel a little more free to ask questions of witnesses. So the day came when this man, Sridhar Ramaswamy, took the stand. He was the CEO of a company called Neeva. Anybody here ever heard of Neeva? How many people here ever used Neeva? How many people are still using Neeva? 0. Because it went out of business. And it did so, the judge found, in part because of the default agreements. It couldn't get distribution. And, you know, every day is an important day in trial, and every day requires intense focus. But there are some times where it just feels like the courtroom is stopping because something important has happened. So I'm sitting at counsel's table, we're watching Dr. Ramaswamy, when the judge asks a question, which he describes. Why does Google pay billions in revenue share when it already has the best search engine? And the judge recounted. Dr. Ramaswamy answered that the payments provide an incredibly strong incentive for the ecosystem to not do anything. They effectively make the ecosystem exceptionally resistant to change. Their net effect is to basically freeze the ecosystem in place. That's what the money was going for. We had openings at the remedies phase. Ian was there, I think. And I thought I was going to be clever. I said, our remedies are antitrust, antifreeze. And can I tell you, Dr. Ramaswamy's testimony was more memorable than my joke. But it's all to the same end. So we had a liability decision, and the liability decision said Google violated Section 2, and that it did so in a manner that precluded competitors from getting to customers. So now we come to the remedies phase. There are a lot of big questions. Elisa has written on a number of questions, and I've only put 2 on this slide. But among the big questions for remedies are, if what Google did that was wrong was to close the most efficient pathways to users, does the remedies decree provide the users the ability to use those most efficient pathways? And not just Google rivals in the traditional sense. You know that the markets in this case were general search on the user side and text advertising on the advertiser side. Not just those kinds of rivals, but are the same pathways important to Gen AI? And I'm going to take a minute to talk about this because I think this is an area in which there's been some misunderstanding. Apologies for all the non-lawyers in the room. I'm going to start with one slide on the law, and then I promise to go on. But it's important because what is a court supposed to do in a remedies phase, right? There is a violation. The judge has found that. Now the judge has got to decide, well, what are we going to do different in the future? And what are the goals that the judge is looking at? The Judge Mehta, explained it very clearly in his own remedies opinion. It's the duty of the district court to redress the violation and restore competition. The remedy must seek to unfetter a market from anti-competitive conduct, deny the defendant the fruits of its statutory violation, and ensure that there remain no practices likely to result in monopolization in the future, right? The goal is if a market has been artificially closed, then steps need to be taken to ensure that it can be open. To apply that test, we ought to take a minute to think about what was the conduct and what are its continuing consequences. Because those are the consequences that are extant in the market when the remedies decree goes into effect. The judge told us the harmful conduct is distribution agreements that provided exclusive pathways to users, like the defaults we've discussed. What are the continuing consequences? So the judge very specifically called out the first three, and I want to take a minute to talk about the fourth. What Google gains is freedom from competitive threats. That doesn't just go away after the liability decision. It gains more users and therefore more scale, and I'm going to explain that. It gains monopoly revenues that it can now use in the future. And I've pulled this out, the judge dealt with this as part of his other categories, disincentivizing Apple from entering general search. This was important to us. So let's go through some of these and see what the judge said and what questions I think remain. The judge took the contracts, and we were in court today to talk about the final language for the final judgment. The judge gave an opinion, asked the lawyers, our state's working with the DOJ and Google to come back with exact language. It turns out we didn't all agree. So we had a hearing this morning to talk about it. Part of this was that the judge said Google had to do contracts differently. He said they couldn't be exclusive. That was his view. But that, he was clear to say, wasn't enough. It's true that the exclusive distribution agreements allowed it to operate free of genuine competition. But to appreciate the full effect, one must look beyond their express terms. This is very important. Because lawyers will have a tendency to concentrate on the language as if that's all one needed to know to understand reality. But practical consequences are very important. The judge says, Google's unlawful agreements allowed it to capitalize on two powerful forces, default bias and network effects. So default bias is what we've talked about. Users tend not to change the default. Sometimes they try and they get frustrated if it's too difficult. And there was a witness for the Department of Justice, a behavioral economist in the liability phase, who explained how difficult it was on Android to make the change. It's difficult because, we put on, as our expert in the remedies phase, Professor Michael Luca from Johns Hopkins, who said search is an experience good. Right? An experience good is something that if you've never tried it, you don't know whether you like it or not. So you got to try it. But how do you get to try it if its very existence, its presence, its competitive significance is kept from you? So that doesn't disappear, even upon changes in some of the contracts. The second is network effects. And I want to take a minute to talk about this. Microsoft put in a document that had this in it, the flywheel. The judge put it in his opinion. I've used it in every slide I've used since, because I think it's extremely helpful to understand the economics, and not just, I think, of Google. I think there's similarities with lots of tech platforms, particularly those that are advertiser supported. So let's just take a minute on this slide and walk it around. If you get more users, if you're Google, you get more advertisers. This is simple. Advertisers would like to advertise to people, and they like to advertise more to where there are more people. You also get more data. That's the point I made before. Users are contributors, not just consumers. Now you've got more data, and now you get higher quality products and services because you've got the more data. And then, of course, you get more revenue to divest in development, but also in future distribution agreements. So you have a contract that gets this spinning, the flywheel spinning. At the end of the day, you've got more users, more scale, higher quality, and more money to buy the next distribution agreement. Indeed, the judge said that exclusive agreements is to secure even more users, thereby perpetuating the cycle. The flywheel. You start a flywheel going, and it tends to keep going. Remember, though, what if you're a rival and you can't get to the users? The judge was equally explicit about this. I like this quote. What for Google manifests as a dazzling flywheel of queries and quality has the opposite effect for rivals. It keeps them stuck in place, or worse, causes a downward spiral. So you don't, if the flywheel is not spinning for you, it is in some sense spinning against you. And that poses huge questions because user data, Google has an enormous advantage in it. For example, on mobile, where, as everybody knows, the only two operating systems in the United States for all intents and purposes are Apple, where there is this distribution agreement, and Android, which is actually Google's platform. The scale disparity between Google and the rest of the rivals is 19-1. And so users don't have the scale they need to try to match Google's quality. Okay. So now we're going to start talking about what I pre-shadowed this for a minute, but we're going to talk about what the judge wanted to do about this. He started with contracts terms. He changed the contract terms. So, for example, instead of being multi-year, they could only be 1 year. This is one of the issues we were discussing in court this morning. But the judge knew he couldn't stop there. This is very important, right? Because sometimes, and Google argued, right? Look, we had contracts that were illegal. We won't have those contracts in the future. We're done. In essence, that was Google's argument. And the judge said no. Merely excising the exclusive provisions from Google's distribution agreements will not unleash competition. Google simply retains too many advantages, and he described them as a decade-long vice grip on default distribution, including its quality, data volume, capacity to monetize search. So, what more was going to be done to deal with these continuing consequences? The judge first turned to the question of scale, or at least in my depiction of it. I think the opinion may have taken these in different order, but talks about data sharing. And Judge Mehta ordered the sharing of some Google data and syndication of search results and text ads. He limited it in scope and time from what we, the plaintiffs, had suggested. And he said, well, you know, we've talked about network effects, we've talked about scale, we've talked about user data, providing a competitive advantage. And he believes that making data available to competitors would narrow the scale gap and in turn the quality gap, right? If 19-1 is a very big disparity, making the disparity smaller, the judge believes would increase quality. And although he didn't go as far as we did, these were remedies that we proposed for precisely the same purpose. But we went on and we proposed more. We proposed very specific remedies to deal with the distribution agreements, the ability to reach consumers. 3, we said the court should ban Google from paying for defaults, whether they were for 1 year, whether they were for a whole company, whether they were for a device, just they should not be able to pay for defaults. We emphasized Apple's potential entry, and we asked that Chrome be divested. None of these requests were granted to the plaintiffs. We thought they were important, but interestingly, the judge understood what the risk was. So I'm going to concentrate on the payment ban because I don't want to take too much time. But you understand that our concern about Apple and Chrome could be long additional conversations. But let's just talk about this. What we said is Google ought not to be able to pay for the default. The judge said, well, let's understand what the rationale for that is. The rationale for a payment ban is straightforward. It would pry open the market to competition. A payment ban, in theory, could bring about a much-needed thaw. He didn't use my antifreeze joke, but he came right back to Dr. Ramaswamy. He said, the revenue share payments, the payments for the defaults, provide an incredibly strong incentive for the ecosystem not to do anything. No. Here he quotes Dr. Ramaswamy. These aren't the judge's words. He's going right back to the Dr. Ramaswamy's testimony that we looked at, freezing the ecosystem in place. So we know permitting the payments carries with it the risk. Judge Mehta did not ban the default payments. And I encourage people to read what he said, because it's longer than I'm going to take the time to go through, and I'm going to try to capture the heart of it, but it's important you know what he said. But among the things he said was that cutting off payments from Google. So let's just backtrack for a minute. People tell me if I'm clear on this. Google's paying a lot of money to Apple, paying money to the mobile carriers in the US, paying some money to Samsung and Motorola. Those companies have been getting the money. If they don't get the money, is that a problem? Judge Mehta said that if cutting off payments could lead to downstream harms to the distribution partners because they would not get as much money. That's my summary of it. A more detailed way is they would either have to put Google on for free, in which case they get much less money, or they'd have to get somebody else to bid for it who would likely not bid as much as Google, since they've been deprived of the same quality advantages. So he said, there are strong reasons not to jolt the system. And he did not accept our proposal. But the question remains, if Google holds defaults, how are competitors going to reach users? The judge addressed this at the end of the payments ban section. He said, these new realities, and here he had previously discussed Gen AI, investment in Gen AI, and the potential entry of Gen AI into search. These new realities give the court hope that Google will not simply outbid competitors for distribution if superior products emerge. There's two aspects of this that I think bear consideration. One is, it is not new to hope that new technologies can displace monopolies. This is, I think, the story of the FTC investigation against Google that was closed in 2013. The FTC was anticipating competition in mobile from companies like Microsoft, Mozilla, and Amazon, perhaps having their own operating systems. It did not come. Two operating systems, Apple and Android, Google with a 95% market share, where default effects are greater. We talked before about them being sticky. They're greater on mobile than desktop because they're small enough to fit into my pocket. The form factor means there's less screen size. And as I mentioned before, Google gets 19 times more queries. The FTC didn't correctly forecast the future. And so, in fact, Google was able to maintain and increase over the succeeding years its monopoly share. Secondly, the hope that Google will not simply outbid competitors. Google spends a lot and it gets a lot. The defaults are very valuable real estate. That's what the judge said. an economist in the audience can correct me if I get this wrong, but I've always been led to believe that monopolists have strong economic incentives to maintain a stream of monopoly revenues. And so what would it take to outbid Google with that incentive? And what it takes us to this question where I think there's been some misunderstanding. There's been some commentary that makes it sound as though Gen AI, you didn't need remedies after Gen AI appeared. And look, there was a lot of talk about Gen AI at the evidentiary hearing in April and May, OpenAI, Perplexity, other companies. But let's understand what the realities of the marketplace are as the judge described them. Is Gen AI a current competitor to Google search? No, a potential threat. Has Gen AI replaced Google search? No. Do Gen AI models depend on established distribution channels like the browser we've been talking about? Yes. Does Gen AI itself need the protection of the remedies? Yes. Well, let me just go down to two. This is a picture that was in the court's opinion of AI overviews on a Google search page. Rather than displacing Google search, what the court found was that AI overviews has potentially strengthened Google's position. Its market share has gone up slightly. So remember, when someone says to you, Gen AI is going to change the world, Google has its own Gen AI. And this is an example of how it's using it to integrate into search. Does Gen AI need the remedies? Well, this is a paragraph that appears on pages 1 and 2 of the judge's opinion. And the first sentence in this paragraph has gotten a lot of ink, or I guess, in the year 2025, a lot of pixels. But the last sentence in the paragraph hasn't gotten as much emphasis. The emergence of Gen AI changed the course of this case. How? The judge goes on. Because the remedies proceedings thus have been as much about protecting competition among general search as ensuring that Google's dominance. Did I run out of time? Oh, okay. So if I hold this, I'll try not to move. Google's dominance in search does not carry over into Gen AI, right? That's what the judge emphasized. But you say, aren't Gen AI chatbots going like gangbusters? Remember, they're a potential threat. And what makes a potential threat? Potential. Sure, Gen AI has potential, but the whole point of that previous sentence was Google could thwart it. And that's why we need potential entrants, because it is the potential entrants that will actually bring the competition that the remedies can empower. But to do that, they need to be able to compete effectively against Google. Last point. Remember the flywheel, the revenue begets revenue begets revenue. The judge said Google has used these monopoly profits to secure the next iteration of exclusive distribution deals, right? So if you've got it, it tends to keep going. But when the judge talks about the flywheel, when he talks about perpetuating the cycle, we think it's very important to understand that the potential here is the possibility, and that we think the reality is Google would be using revenues derived from the illegal contracts to have revenue to buy defaults in the future, even during the remedial period. My boss, the Attorney General of Colorado, Phil Weiser, gave a speech last week in which he said Judge Mehta's conclusion was that ending payments would have negative consequences to companies who received the payments. But he said, and I'm quoting, "This conclusion is wrong because it would justify any monopolist, say the old AT&T, continuing to act as a monopoly and use its monopolistic tactics because it was supporting worthy causes." Or to put it in my language, if a monopoly does something wrong and gets to split its funds with somebody who hasn't done anything wrong, that doesn't create any legitimate expectation on the partner to keep receiving those funds. Indeed, the whole point of the competitive market is that there are no guarantees. So this is where we are at the moment. The judge will issue a final judgment. He said today he hoped to do it quickly. And the remedies process will begin. There's going to be a lot of work to be done. I represent a bipartisan coalition of 38 states, will work very hard to make the remedies, whatever they are, as effective as we can. So thank you very much.
Sit down.
Sorry.
Please go.
Really.
We'll continue to the next portion with a chat now. So, hi everyone, my name is Filippo Lancieri. I'm an associate professor of law here at Georgetown. And really a pleasure to have you here, John. I was telling my students, that like, you should come because John is going to do the best job explaining this case that I think anyone could ever do. And I feel totally vindicated now with a perfect summarization and an explanation. And I agree with you, the court is so close that some of my students last year in antitrust, we actually went to the trial, to the remedies remarks, to the discussion. It was really interesting. Oh, sorry.
So I'm gonna, is this on?
Sorry, reintroducing myself for the people online. My name is Filippo Lancieri, and I'm an associate professor here. So thank you very much for an amazing explanation and event. And I remember being courtroom with my students in April this year, seeing you argue there, and it was fascinating. So I'll just ask a couple of questions and you move to Q&A, so this will be perfect. There are a lot of people here, I'm sure, I want to ask you questions. I wanted to actually, it's very easy to be yesterday's quarterback, what is the expression that like it's easy to always look and see where we are. I wanted to take you back to when you first started working in this case, like 2020. And so what's happening back there? Like basically the US has not brought a large monopolization case since basically Microsoft, like 20 years without a single large investigation. And some investigations happened and were closed. And I remember at some point, Carl Shapiro was one of the chief economists at the DOJ. Someone asked him, why are you not bringing monopolization case? And he gave an answer, it was kind of like there are no monopolies in the US economy or something like this. And so what I wanted to ask is like, if you go back to 2020, what were your expectations back then? You're like bringing one of the largest landmark rulings cases for many decades. Would you see yourself basically now in 2025, kind of looking at the remedies, looking at the liability opinion, do you think would have been happy? And would you be discussing like, oh, maybe there should have been a breakup, but everything that we achieved so far. So how do you think about this flashback analysis?
Just a couple of things. I think is this on? Is this okay? Yeah. In 2020, I would have thought I looked younger. I would look younger than I do now. So I got that one wrong. But before we go, I just want to say one thing. Your class came and sat in the courtroom, and on the very last day of trial, the remedies proceeding, the very last thing the judge said was how inspiring it was to see your students in the courtroom and hope that your students would learn and take inspiration from what they had seen. And I remember when the class was there, and I think that's why it was so important for you to bring them, because we all share the goal, the judge's aspiration that will be an outcome. 2020. Here's what we thought. We thought the contracts, we had a very strong case that they would be judged to be illegal. The states, the Colorado states, the Colorado and Nebraska states, thought there were some other allegations that would show the full effects of Google's conduct, and the judge did not accept them. But we also always thought, and I'm not saying would have been able to forecast OpenAI's market cap, was that it was going to come down to remedies, that there was always going to be an argument that all you had to do was stop the particular contract clauses that were assessed to be illegal and you'd be done. And that a fulsome set of remedies wouldn't be put into place. And so I will say all through the process, even though the liability process was a very extensive one, we always thought it was going to come down to remedies. And that what we wanted to do was to have an antitrust case that would vindicate the law, as you say, first big case since Microsoft, but also open up the markets. Because at the end of the day, that is what tells us whether a antitrust enforcement action has been successful or not.
And was there a discussion like, oh, maybe this will be a case where you're going to ask for structural separation again, even back then, this will be an effective remedy? We thought of back then, or like how does this evolve over time?
I'm not sure I remember exactly. I will tell you one feeling I've had for a long time, but I can't tell you it was a motivating force at that moment, was there was an argument made by monopolies that all eggs are scrambled and cannot be unscrambled. The scrambled eggs doctrine, right? It's too complicated to take apart the case. I have thought that defense ignored the mandate of the United States Supreme Court. I think it's International Harvester. I may be wrong about that citation, that divestiture is the most important remedy. And I have for a long time thought, I gave a speech when I was at DOJ about this, that behavioral remedies can have problems being measurable and implemented and monitored. And I thought that divestiture needed more focus than it was getting at the time.
Interesting. And I wanted to build on what you said about the other claims, right? So some of the students here are from international countries. We have people joining us online from other places. So when you're looking to bringing this case and thinking about the remedy design now, how much are you looking and thinking about what's happening in other jurisdictions where Google is being sued, right? There's a professor in Copenhagen and estimated that Google has been subject to more than 110 lawsuits on antitrust basis around the world. And we have seen cases in Europe, like one of the cases that you brought was kind of like the equivalent of a self-preferencing case in Europe. And the remedies there have not been very effective either, So how, when you're looking, like even though the US is kind of stuck into bringing monopolization cases, the rest of the world was not. So how much did this play into your consideration into both the liability and the remedies and how to think about the structure of the case?
I don't think it played a consideration into what we wanted to allege and how we saw U.S. law being interpreted. It did have important ramifications. So there was an extensive discussion of what happened in the EU as a result of the choice screen remedies on Google. And the fact that they, by some estimates, moved something between 1% and 4% of market share. They had very little effect. And that, I think, was sobering for everybody. The judge says in his remedies opinion, he's not going to use choice screens because of that experience, really more than any other. So we certainly looked at that European experience to see whether choice screens would be a useful way to go. We did propose them in a small way. The judge decided not to use them at all. But the learnings came, I think, primarily from Europe.
And a final question that I open, so please prepare your questions. We're going to get the questions from both here and from the online audience. And I think one thing that always interests me when someone like you has been in antitrust for such a long time is about the timing of these cases, right? You filed a case in 2020, and here we are, 2025, basically not even getting the final remedies opinion yet, and there's appeal, there's everything that's coming forward. And in a way, the case was scrambled by the evolution of technology. And I think there's limits to how much has impacted the case, but it ultimately was impactful for the case. So how do you see, as someone who has been in antitrust for such a long time, as a way to bring this case faster and litigate faster and move faster in all the steps? Like, do you have, like, can you think of a way looking back now to say, is there anything that was under your control, under the judge's control, that could basically have sped it up or not? Or you're just playing this catch-up game forever?
Well, this is where I think a real study of this case has to start with the FTC decision in 2013. Imagine if the FTC, it was many of the same allegations, had brought that case in 2013, even if it had taken 5 years, 2018, and I'm making that up, but just, that I think in the history of the Google litigation will be seen as a very important moment. And I think it's very important that antitrust enforcers look to the future in terms of threats, because it's antitrust enforcers who are thinking about businesses that are not yet in the market. Businesses that are in the market have lawyers and lobbyists and market share and revenues. I think it's easy to second guess, but I think it's clear that the FTC's notion that mobile was going to be a way around the Google monopoly, that it would defeat the monopoly, failed to understand the real incentives Google would have to monopolize mobile even more than desktop, that its share is greater. So when we came along in 2020, we understood that that case could have been brought and wasn't, but we felt it was important nonetheless to change the ecosystem, because this was a critical mechanism by which users get information. And because user information, the scale point I made, was at the heart of this case. So we saw a real competition problem when we saw very important implications for antitrust enforcement.
Very interesting. Last Friday, my new class, we were actually at the Virginia trial, and in front of the Virginia courthouse, the ad tech trial, there is like justice delayed, justice denied. It's something that is very interesting to keep this in context here as a fun. But questions, please. Anyone from the audience, please raise your hands. We have a mic. We have a hand over there for someone. And you spring.
Thanks very much, John. A super summary of the case. I know you've been very close to it for a long time. I'm Mark McCarthy with Georgetown, by the way. What are your hopes for the data sharing remedy? I mean, that seems to be the big one that's left after the default payments are going to be allowed, and the company's not going to be split up. I mean, a company like OpenAI has ChatGPT, and it to some extent is beginning to act like a substitute for search, but they don't have a search engine. They use Bing. But maybe with access to Google's data, a company like that could do a pretty good job of mimicking the success that Google has had in developing a high-quality search engine. How much hope do you put in the remedy for data sharing?
I'm hopeful that the data sharing remedy gives the short and medium term boost to companies that include Gen AI companies, particularly if it gives them information on recent events, right? We all know enough about LLMs now to know the LLM I populate with writings can give me very good analysis of those writings, but doesn't tell me about current events. But general search is about current events a lot. So remedies that get, and the OpenAI executive who testified talked specifically about the need to have the index to understand what was being looked at by users around the web. So the remedies, if they work, and they're not as extensive as we had hoped, the judge hopes will provide scale and quality, and in part deal with the issue around what are called long tail queries. If you typed into a browser, who is Jonathan Sallet, there is no more longer tail query in the universe, right? So just to give you
There's no Wikipedia page, there must be one.
No. But Mark, my concern is, and I think I said it because we proposed payment bans, focus on Apple and Chrome divestiture, that merely having the short-term or long-term quality won't result in the ongoing sustainable flywheel if the companies haven't been able to access customers in a manner as effectively as Google has been able to.
We have a question there. John was particularly, when you're preparing this, he said he was particularly keen to take questions from students. So if you have questions, please don't feel shy. Ask a question. It's more than welcome. I have a question there, then we have a question here. Yes, please.
Hi, thank you very much for this. I'm a reporter for AFP News Agency. I wanted to ask, it's sort of like a lobbying question. It's like, what is the role? Especially, I'm thinking back to the 2013 FTC decision, just to walk on. There was a lot of talk that Google's lobbying power is what made the FTC ultimately walk away. And then it's just sort of funny in this case with the judge at the bench trial. I'm not saying that he was lobbied, but this is sort of like sometimes when I read the opinion, I mean, there's a lot of people who sort of say maybe just watch too much CNBC and is buying sort of the AI hype in the opinion that was made. By going too far and thinking that Gen AI is going to be competition to Google. I was just sort of wondering how important are the broader forces of just all the efforts made by Google and companies like Google to sort of influence the outcomes in these kind of cases, with the observation that a jury in San Francisco in the Epic case just said against Android went. They decided against Android quite quickly and had no problem doing it, while judges have always been a little bit more have been more lenient with big tech companies.
I never saw anything that seemed to me to have any impact on what the judge decided in this case, except what happened in the courtroom. Witnesses testified, lawyers argued, experts gave their analysis. If one reads Judge Mehta's opinions, there are hundreds of pages of detail. I believe these opinions are based on what happened in the courtroom. But I also believe, and your question goes to a point I made before, that I think people are not accurately reading everything that Judge Mehta said about Gen AI. And this is my point, that he's careful to say that Gen AI is not a current competitor of Google, that it is not currently replacing Google, that it needs the benefit of remedies. I think that's very important for us to understand, because we're in a situation where the remedies package needs to be fulsome and effective in order to get the potential benefits of Gen AI in this space. And this space, of course, is what the Google case is all about.
Can I just a quick follow-up? Did you ever consider bringing this case as a jury trial? Why not, at any moment?
I don't remember that we ever considered it.
Interesting, yeah. So please, there's a question there from students here, please.
Hi, thank you for being here. I'm Bhavna. I'm a third-year law student here. So for me, it's very hard to digest the fact that Judge Mehta was somehow able to overlook the fact that Google itself is a top 2, top 3 competitor right now in the Gen AI field with its Gemini LLM. And so I was wondering if you have any insight as to what his rationale was based on what happened in the courtroom for being able to set aside that fact when he said that Gen AI competitors give him hope.
I mean, the best way to understand what Judge Mehta said is to read this passage in his opinion. There's a part of the opinion where he talks about why remedies will extend to generative AI models. He's emphasizing, I think, chatbots there. But he also talks about features like AI overviews. And I think his own words are the best judge of this. He did say that there was reason to believe that AI overviews on the Google search page had increased the Google market share. I think it was 1.5 to 2%, but by a small amount. So the fact was clearly in the court, and the fact was not just available to him, he used it himself.
Here, let's take 2 questions at a time, and then we can go more quickly to the question. One over there, one over here in front.
Hi, Jonathan. I'm Dave Michaels. I'm with the Wall Street Journal. I cover antitrust. Given what you said about the opinion not heeding the lessons that the FTC inquiry shows from 2013, how are you thinking about the potential appeal on remedies at this point? And then do you think there are any lessons from this opinion and from this effort for the other Section 2 cases that the DOJ and the states have filed against other big companies in which they're seeking structural relief?
Let's get here so you answer 2 questions, then we can move first into that. Yeah, please.
Hi, John. My question is, so you talked about how search engine is kind of like the experience of search is very important for consumers, and how maybe that's one of the reasons why choice screens have a limited impact, because the learning curve, for someone to learn a new browser is really hard. And also like Google bundles its services such as YouTube, Maps, to like its and accounts to like the Google search. So I was wondering, like, is maybe debundling or like any sort of additional remedies talked about for the remedies section? Or yeah.
So part of what Judge Mehta ordered was that contracts not be able to connect the availability of, say, Google Play to the willingness to use search. So that is part of what he's implemented. We proposed our own remedy, the states, that would have gone further than this, and that would have had Google pay for a public education campaign to try to inform users, even potentially having a circumstance where users could get paid to experiment. This is spawned by a paper that has been widely circulated over the last year by very well-known economists. The judge chose not to go that route. And the reason I raise the issue is that without experience, if users are not going to use rivals, and if rivals cannot effectively get to consumers, then the question is obviously patent. How will users ever get experience that would allow them experimenting with others, that would allow them to decide whether they would prefer an alternative to Google? That was the concern of us. On your question, we were in court today talking about what the final judgment would say. We've made no decisions about any potential appeals. Google has said it will appeal. We anticipate that.
We have some online questions. So I think there's 2 online questions.
Yes, and we're going to run over a few minutes late, so people are free to stay or go since we started a few minutes late. So 2 questions from online. The first one is asking whether the plaintiffs considered also suing Apple to frame the issue as a de facto non-compete agreement. And the second question is, what could have been the most effective remedies to preserve competition in Gen AI that were not approved by the judge?
Well, I guess to take them out of order, we were proposing the payment ban and Chrome divestiture precisely because we thought that would give open pathways, including for Gen AI. And when I argued unsuccessfully the notion that the Chrome browser should be divested, what I suggested was that another company, including a company like, OpenAI and Perplexity, both said they would be interested in purchasing Chrome during the trial. That could provide a basis through which a significant percentage of search queries could be in the hands of a new competitor, and that could provide efficient distribution to an important audience. The judge thought we went too far on that. So we face the circumstances that I've described. I think I forgot the first question. I'm sorry, Elisa.
The question was like, if you ever consider suing Apple as well as part of the litigation.
We had a lot on our hands.
Okay, so let's get the final 2. If you have any final questions here, there in the back and one here, and then we'll close.
Hi, thank you so much for such an insightful session. I'm Lalantika, I'm an LLM student. I have two questions, sort of related, sort of not related. Firstly, given that divestiture was not sort of agreed upon or proposed as a remedy in this case, do you feel that in the ad search case, could it positively or negatively impact the ongoing ad search case? And secondly, does the DOJ, is it one of the DOJ's strategies to sort of shoot for the stars so that you'll at least land among the moon, shoot for the moon so you'll at least land among the stars when it comes to proposing remedies, which is to ask for more extreme remedies, so at the very least, if it sort of gets cut down and given lesser remedies, it would still sort of have some net impact? Or is it just that, do you say that this is the only way that could happen?
Well, on the first one, I'm not in the ad tech trial, so I'm not in a position to answer that. And I don't work for the DOJ, but speaking for us, we asked for the remedies we thought would be needed to restore competition. That's how we looked at it. We thought they were holistic. We thought they had to work together. We thought they would be effective, but also we felt that they were required.
Final question over there.
Good afternoon. Thank you for the talk. I'm an undergraduate student here at Georgetown. A recent, within the last couple of days, development is that Google recently limited the number of pages you can look at from 100 to 10. And some AI companies, such as Perplexity, have come out saying that this was a direct means in order to enhance the ability of Gemini compared to competitors to essentially cut out LLMs that scrape vast amounts of the internet on a per query basis rather than the tokenized training that LLMs such as OpenAI use. I was wondering if you have any thoughts on that and sort of how that sort of very monopolistic behavior fits in against quite literally this morning's backdrop of trying to share data and open up the space to competitors.
Just a connected question. So do you think these remedies will be alive for a very long time? I mean, the order is like 6 years.
Oh,
But how do you feel like the
this.
market is going again, again, and
I should
again?
have said this. The term of the decree is 6 years. So there's going to be a lot of work over the next 6 years to try make the remedies as effective as possible. And one of the things I said in court today, I'd just like to repeat briefly, is this. No, I haven't said it to you, right? So it's not repeating. For this remedies process to work, we, these 38 states and territories, will work with Google, we'll work with the DOJ, we'll work with current competitors, business partners. But what's really important about making this remedies process work is that we pay attention to people who aren't in the market, what the competitors understand, what potential competitors understand will be the effects of different aspects of the remedies decree. And I said this morning that we wanted to engage with those entities because they are the ones who have the power to bring competition. It's very important that the remedies decree not be understood as if it were something with a tennis match with the DOJ and the states on one side and Google on the other. We really want to understand from companies who want to come into these markets how it is working and what they think they see on the ground. Because without that kind of input, we ourselves will not be fully informed and able to do our best job of monitoring and making the remedies process effective.
Okay, I'll ask a final question from my side. So taking the bird's eye view again. So in 10 years from now, when people look back into like the Google search case, what do you hope and what do you think like is going to be the legacy of this case, the entire litigation, the remedies, however they are implemented, you know, like so. And so we're teaching students in 10 years, how should we be talking about what the Google search case overall saga represented for antitrust policy in the US and abroad?
So this really is only my view, but I want to go back to something you said. We went through a period in the United States when there were no there was bizarre voice, but there was basically no big monopoly litigation brought for 20 years. But there is monopoly, and there is monopoly power, and there is conduct that plausibly threatens competition. And I'm hopeful that one looks back at this case in 10 years and says, this is the beginning of a time when monopoly power that was being abused in violation of the Sherman Act was again the subject of active enforcement, active litigation, and on a whole, a set of active remedies to restore competition. So if we've begun that new phase, that would turn out to be an important legacy.
Thank you so much. On behalf of Georgetown and all the students, thank you. And thank you also for your public service. I think it's very important to stress a lot of work, and it's really an honor to thank you very much.